Welcome, everybody. Thank you for coming. Welcome to everyone on the webinar. Hopefully that you can hear us and see us. I'm going to give out my cell phone number right now in case there are any problems for those of you attending via webinar so that I can hear about them right away. My cell phone number is 831-236-1259. I'm Christine Reed. I'm a shareholder with Lobel & Lynch in the Monterey office. I'd like to welcome you all today to our annual seminar. We're happy that you're able to come, whether you're attending via webinar or via seminar. And the only problem, if you're not attending here in person, is you're going to miss some good cookies and some snacks and cocktail hour after the seminar. So we're next year, if those of you attending via webinar, try to be here in person. But I wanted to just say briefly that most of you know this because you're all friends of our firm, but in case you don't, we have two offices, one in Monterey and one in San Francisco. And we practice primarily civil litigation from the defense perspective in many different fields, including personal injury, public entity, toxic tort, and construction defect, and many other fields in between. And so we've got a lot of experience, and two of those very experienced attorneys that are going to speak to you first about a California law update combined with insurance coverage case law that has recently come out are Charles Redfield and Bridgman. And they both have about over almost 60 years of experience combined. They've been with the firm for, Charlie has been with the firm for over, 28 years. And Kurt came around a little later. He's been with the firm for about 16 years. So they've been longtime attorneys, have a lot of wealth of experience and knowledge, and they're going to impart some of it today. So again, welcome, and I'll just let you know, to those of you on the webinar and in the room, that after their presentation, this presentation is going to be about an hour and a half, and then we're going to have a break, some refreshments, and then we'll take about a 10-minute break. We'll come back on, and we'll have two presentations after that on marijuana law, and then a presentation by our guest speaker, Tammy Rockholt, on some very important nursing related information, expense, and damages analysis that's very helpful, particularly for personal injury matters. So I'm really looking forward to her presentation. All right, thank you very much.
Welcome, everybody. I'm Kurt Bridgman. I've been with Lobel & Lynch since 2000. I graduated law school in 1989 from the University of Southern California. 28-year trial attorney, practiced defense litigation, mostly focused on housing, property, complex litigation, and class actions. We're here today to give you a little update on the cases that we thought were pretty significant that came down last year. And the first case I'd like to talk about is Rubenstein versus Doe. It's a California Supreme Court case, and it attempted to clarify the statute of limitations versus the government claim statute with regard to molestation claims that occurred when someone was not over 18 years old. The court in this particular case was confronted with facts, allegations that were made by the plaintiff that she suffered some level of molestation when she was 16, 17 years old in high school, and that happened in 1993, 1994, and that she had recently accrued by those problems that she suffered back then had recently resurfaced. She had seen a doctor. The doctor had certified that this was a new event, event triggered by these events that happened many, many, many years ago. the plaintiff filed suit against the school district. The school district demurred, saying the statute of limitations for these types of claims, which had recently been extended by the California legislature, had not impacted the government claim statute. As many of you know, when you sue a public entity, it's a requirement that before you file suit, you file a claim against that entity to put them on notice. They have a chance to adjust, settle, or reject. And in most cases, they reject. The California Supreme Court reversed the Court of Appeal. The Court of Appeal had found that there was, because of this new legislation, extending the statute of limitations for a new accrual, said the claim was timely. California Supreme Court reversed, saying that the legislature's intent to extend the statute of limitations for these types of claims was fine, but it did not impact the requirement when suing a public entity that a claims be presented timely to the government entity. And based on the clear statutory requirement that hadn't been adjusted by the legislature, that claims needed to be presented, dismissed the case. The import of this case, among many things, is that when public entities are in the litigation, they have many more defenses, including governmental immunities and the claims statute, that are potentially subject to demur, motions for summary judgment to get out of those claims. The second case I want to talk about before I hand it over to my partner, Mr. Redfield, is this is a collateral estoppel case, and it may be important for some of the cases that you're handling. In this case, the dispute was over between someone who claimed that they had purchased the property with an installment contract and were paying over time. The defendant said, no, that wasn't the case. You signed a lease option and you had paid on the lease, but then the option had expired and you were just a tenant now. They were in a big dispute over who was the actual owner of the property. The tenant stopped paying. The defendant moved to evict them. And the tenant also filed a civil lawsuit claiming fraud in the inducement, that you were my real estate agent, you told me all these things, that I was going to be able to purchase the property, I was just paying over time, there was no lease. The court, the unlawful detainer court, was confronted with the issue of whether the person was a tenant, the plaintiff was a tenant, or whether they were a person who had a vested interest in that property. The tenant sought to quash the subpoena for the unlawful detainer for the eviction. The court held a one-day hearing, listened to a number of witnesses, including both the plaintiff and the defendant, took exhibits, testimony, and ruled that there's no ambiguity here. The person was a tenant under this lease to purchase. The option to purchase had expired, and therefore they were evicted. In the civil lawsuit, the tenant wanted to argue all his fraud claims, and the landlord brought a motion for summary judgment saying there's no issue here. This has already been decided by the unlawful detainer court. And usually, unlawful detainers to evict someone are very summary proceedings. They last about an hour, and they have no collateral estoppel or res judicata effect. This was different. Because there had been testimony, because there had been a written opinion by the court found that you've already litigated your claim. It's done, and entered judgment for the landlord in that particular case. And now I'd like to hand it over to Mr. Redfield here.
Thank you, Kurt. Hello, everybody. Again, my name is Charlie Redfield. I'm a shareholder with Lowball & Lynch in San Francisco. We really appreciate everybody coming out and participating in this seminar. We take pride in our legal work and pride in our presentations as well. I think you'll enjoy today's seminar. Before I go on to the next case, Christine's right, I have been practicing for quite some time with Lowball & Lynch. In fact, I practiced so long with Lowball & Lynch that I actually practiced law with Mr. Lynch and Mr. Ball. I just missed Mr. Lowe. And I get this question a fair amount, is that whether the name Lowball & Lynch is a brand name or actually was in fact three individuals. I want to let you know that yes, there really were three individuals named Lowball and Lynch. And the original firm name was Lowe and Ball. And there's a story why Lynch was added. We have grown accustomed to the name and used to, when we provide low settlement offers, getting the retort, well, of course, it's a low ball offer. But we have grown accustomed to that and actually take pride, I think, because we have a lot of affection for Mr. Lynch, and I did for Mr. Ball when he was alive, and for all of our mentors and some of the elder partners that we had with us that trained us. So we take great pride in the name, not because it has a cachet or a cute implication, but really because we're proud of what our predecessors have established. So with that, I'll leave that aside. I'll go on to the first case I'm going to talk about. The section of cases that I'm going to be discussing this first part is going to be dealing with employment law cases. The first case is, if you want to, I believe these materials coincide with what I have, is at page 4. It's Augustus versus ABM Security Services. This case involved an interpretation of the what we call the break statute. That California Labor Code section 226.7 requires employers to allow employees to have breaks for every 8 hours or so of work. And this case dealt with the issue of whether an employee who was on call could be considered to have taken the break. The main plaintiff was Jennifer Augustus. This eventually became a class action. And she worked for ABM Security Services. And ABM Security Services policy was that when their security guards were on break, they were required to have their walkie-talkies and to be on call, such that if someone called them and they were needed right away, they had to stop their break and then go deal with whatever was necessary as part of the call. And then that was the end of the break. Ms. Augustus sued, saying, well, that was not in compliance with the Labor Code section, and at trial, it was agreed, and the class was awarded $90 million. Unsurprisingly, the defendant decided to appeal that. The class was about 14,000 security guards. The appellate court first ruled that in favor of the defendants. And the appellate court found that yes, as long as the employee was provided some sort of a break, being on call didn't seem to violate the statute. Plaintiff, unsurprisingly, looking at a $90 million payday going away, decided to take it up with the California Supreme Court. And the Supreme Court reversed the appellate court. The Supreme Court was aligned with the plaintiff in their interpretation of the statute. The Supreme Court felt and held that the break has to be uninterrupted, that you have to allow the employee to have all control over the employee's time during the break. The employer has to relinquish all control for that break to be in compliance. So it was a major victory for security guards. Now, the California Supreme Court did give an exception or a bit of an out on this for employers. The California Supreme Court held that an employer can call an employee during the break and ask the employee to come back to work if some emergency or exigent circumstance occurs which requires the employee to stop the break and resume working. But the California Supreme Court said that this needed to be the exception, not the rule. It sort of sets up further litigation, it seems to me, that little language, but that is what they said. It also, the California Supreme Court stated that if the employer does interrupt the break and make the employee return to work, then later on that day, the employee is entitled to get the full break. So if the break only lasted 5 minutes and was supposed to last 15 minutes when the employer interrupted the break, the employee gets the full 15-minute break later on. So that was the one exception the California Supreme Court gave for that case. The second case I want to, thank you. The second case that I want to discuss is at page 5. This is Orlando Nakai, and I got to tell you right now, I don't know how to pronounce these names I'm saying, so I may be butchering if you know these people or know the names better. I apologize already, but I'm phonetically pronouncing them. Orlando Nakai versus the Friendship House Association of American Indians. I think of this case as the danger with hiring family members. The plaintiff, Orlando Nakai, was the son-in-law of his boss. And Orlando's wife, the boss's daughter, came to her mother and complained that Orlando had become angry, seemed dangerous, had a gun, had made threats to her and people in the employment. And with that, he was let go. So Orlando claims that he was thus a victim of marital discrimination. Marital discrimination is a classification that can be subject to a discrimination claim. But what's interesting about this case is it differentiates between marital discrimination based on the status of being married as opposed to being married to a particular person. And the law allows a lawsuit being filed by a plaintiff who is the victim of marital discrimination if the discrimination is because the person is married in general. In other words, the person's marriage somehow prohibits that person from doing a necessary job duty, and that's discussed with the employer, as opposed to, in this case, which was, well, we want to fire you because you're married to my daughter and you're threatening her. And a case which involves discrimination against a particular married person because of who that person's married to is called a conduit case. And a conduit case is not allowed to be the subject of a marital discrimination case. So that's one of the keys in this case. The other part of this case is it does a fairly good discussion of whether the reasons for letting Orlando go were not pretextual or discriminatory. Given the reports of Orlando's behavior, especially the threats that he potentially made to coworkers, the court found that the reasons for letting Orlando go were not pretextual. There had been a legitimate non-discriminatory reason for terminating his employment. Oh, one other part of this case that's interesting is Orlando also criticized his ex-employer and as a ground for saying that his termination was pretextual and should not be allowed as a matter of law, is that his employer did no investigation of the grounds that were ostensible grounds for his firing. Orlando was an at-will employee, and the court held that an employer of an at-will employee has no duty to perform an investigation of these claims, and thus there was no requirement or duty to investigate by the employer under those circumstances. So that's another important upshot of this case, or lesson of this case, is that at-will employees do not have the ability to claim that a failure to investigate by that employee's ex-employer demonstrates a discriminatory reason or can form a basis of a claim. I'll move on. So the third case that I'm going to talk about, which is still in the employment law arena, was a racial discrimination case. And this was a federal case, and it's called Efrain Reiniger versus Roseburg Forest Products. The plaintiff in this case, Efrain Reiniger, was one of two Mexican-American employees in a predominantly white workplace. He claimed that one co-employee in particular was making racist comments towards him, not treating him well. He also claimed in general the employer had made a hostile workplace because of his race. And the plaintiff requested the employer that he not be assigned to the same job duties and assignments with the person who he said was making these racist comments and not treating him well. And for whatever reason, according to the plaintiff, the employer refused to accommodate this request and continued to place Mr. Reiniger with the alleged racist employee until one day when Mr. Reiniger saw yet again the posting of job duties that he was unfortunately assigned to be working with this racist co-employee, that he'd had enough and he walked off the job. A couple days later, he was terminated. So he sued the employer, this Roseburg Forest Forest Products place, for racial discrimination. And I only am familiar with the federal court case. For some reason, the trial court felt, despite all this evidence that's cited in the appellate court case, there was no triable issue of fact, and that the employer was entitled to motion for summary judgment on the claims that there was no hostile work environment, there had been no disparate treatment, there had been no retaliation. I give a lot of credit to the defense attorney being able to convince a district court judge of that, given the facts they had in this case, but again, I'm not quite sure what was submitted to the trial court. Anyway, unsurprisingly, given this factual record, the appellate court said there was at least a triable issue of fact that should go to the jury, whether these types of facts set forth a hostile work environment. As far as the disparate treatment prong, there was also evidence that the employer had searched Mr. Reiniger's locker when virtually nobody else's locker had ever been searched. And the retaliation was the eventual termination in addition to the other treatment. So the appellate court had reversed the lower court ruling. And one of the bases of the lower court ruling was that the Roseburg Forest Products had performed an investigation, allegedly, of these claims, but nothing was done as a result of the investigation. So Roseburg Forest Products claimed that, well, we've done this investigation, that's what we're in compliance now with these statutes because we've done the investigation, so we should still win. The appellate court rejected that claim. The appellate court found that if you performed an investigation without prompt and effective remedial measures, given the factual situation in this case, it was not enough to just say we've done the investigation and now we're terminating him. That put another way, the investigation did not act as a shield to allow the employer to avoid having this type of a racial discrimination claim. The last employment case that I'm going to go over is not really an employment case in the similar vein that I've gone over previously, but it does involve employment. It's more of a tort case. And it's on page 8 of your materials. It's Summerall versus Modern Alloys. This case deals with the going and coming rule. Those of you who handle tort and negligence cases are familiar with this general principle. Let me just quickly review it. As you are aware, I think, that an employer can be liable for the torts of an employee, vicariously liable, if the employee does the tort or action in the course and scope of that employee's employment. And of course, the question historically became, well, what about when the employee is commuting to or from work? And it's a black letter California law. It's called the going and coming rule, that an employer is not liable for the torts committed by an employee when that employee is commuting to and from work, except, of course there's an exception, right? Except what's called the business errand exception. And so if, in fact, the employee is on an errand for the employer while in the course of commuting, then the employer can be vicariously liable for the torts of the employee. So in this case, the employee was actually paid for working just at a work site, but the employer required the employee to drive from his home to the yard, pick up more of co-employees, and then drive to the work site. And again, the employee is only paid for the job at the work site, which, reading this decision, made me think he's got a pretty good hours and a claim here against his employer, but that wasn't the issue in this case. So as you can probably anticipate, on one of the employee's commutes to the yard to begin his day, he was involved in an automobile accident with Mr. Sumrall. And Mr. Sumrall sued the employee's employers, Modern Alloy, saying, well, you are vicariously liable for your employee's negligence in getting involved in this accident when he was driving to work, given these circumstances. Of course, the employer said, well, no, you can't sue me because I'm not vicariously liable because he was commuting, and it's the going and coming rule. And the employer filed a motion for summary judgment, which was granted by the lower court. The plaintiff appealed, and the appellate court reversed. And the appellate court, in analyzing the facts that I just described, felt that, or believed that, there were sufficient factual evidence to establish a triable issue of fact as to whether the employee was in fact subject to this business errand exception. Those of you who are familiar with California procedure know that to defeat a motion for summary judgment, the opponent just needs to show a triable issue of fact concerning an issue, and the entire motion is denied. So it's important for this case to understand that the appellate court did not find, given these facts, the business errand exception applied. Rather, the appellate court held that given these facts, there was a triable issue of fact as to whether the business errand applies. So it wasn't quite black letter law on the issue, but it does establish somewhat of a boundary as to where a business errand situation could occur. And so with that, I turn it back to Kurt. Oh, sorry, I gotta give you the mic.
Well, the next case we're going to talk about is Sanchez versus Kern emergency. The facts of that case are really kind of tragic. High school football game, a football player struck in the head, goes to the sideline. They had a paramedic there who did a paramedic examination, Glasgow Coma Scale. The young man was fine, but he had some concerns about the young man, so he said he should go directly to the hospital. They took the young man directly to the hospital. He got there in 46 minutes. They did a CT scan. They discovered a subdural hematoma. It got worse. He had a stroke. A lawsuit filed against Kern County for failure to act appropriately at the football field and take the young man immediately to the emergency room. The Kern County and the hospital and the paramedics brought a motion for summary judgment in this medical malpractice case. On a medical malpractice case, you're required to have a doctor testify that the medical handling was outside of the standard of care. The Kern County emergency had doctors testify that what was done was consistent with the standard of care, and that the lapse from the time of the injury and the initial evaluation to the time to the hospital wouldn't have changed what occurred to the young man. The plaintiffs opposed that with their own expert, but their own expert's declaration said in very short fashion that they were outside the standard of care, that they had violated it, and that had they got the young man to the hospital sooner, things would have been different. The weakness in the plaintiff's expert declaration was objected to by the hospital and Kern County. And they stated quite simply that he said something, but he really hasn't provided any factual foundation for his opinion. He hasn't addressed the literature that was cited by the defense experts about the time lapse. And in essence, he's made an opinion, but he's provided no factual foundation. He hasn't addressed the undisputed facts of the case, and that the court should strike that declaration. The court did indeed strike that declaration. The case was appealed to the California Court of Appeals. The California Court of Appeals was in line with the trial court, and they point out that, having an opinion is fine, but an expert opinion to be admissible needs to address the undisputed facts, be based on something other than conjecture and speculation. And there was no reasoned discussion by the plaintiff's expert about why the lapse, if it would have been shorter, would have changed anything. He just said it would have been different. The Court of Appeal struck it. Motion for summary judgment affirmed. The importance of that case, obviously, which we deal with a lot, is the quality of expert testimony, especially on motions for summary judgment. The defense does many times have the better expert, and it is really important for that expert to specify strong grounds for their opinion, and then for the defense counsel to attack the plaintiff's opinion when it comes in, because many times they're very thin. They just try to create a tribal issue of fact and get it to the jury, hoping for potential settlement. So let's move on to the next case, which is PG&E versus Superior Court of San Mateo. You'll see PG&E come up a lot in the decisions today. I think this was 4 years after the explosion in San Bruno, and PG&E ended up in a lot of lawsuits after that for all sorts of reasons. This one, at least on the facts, was kind of a stretch. The facts of the case were pretty simple. Family went camping at Samuel P. Taylor Memorial Park in San Mateo. A tree fell in the night, severely injuring somebody. The plaintiffs brought suit. The defendants, including PG&E, moved for a motion for summary judgment, citing the Civil Code Section 846, which is the recreational use immunity statute, which says that owners of land who allow their land to be used for recreational purposes owe no duty to the people who use it. But there are exceptions to that immunity, and one of those exceptions is if you charge to get into the park compensation, the immunity doesn't apply. PG&E did some work around where this accident occurred, and they had an easement at the park to do that work. And they said, well, I understand there's an exception to the immunity, Your Honor, But we didn't receive any of the compensation. We were simply there doing work near where this accident was. This recreational use immunity statute should apply to us. The Court of Appeal said no. If there is, even if you are a landowner who is one of many landowners who doesn't receive compensation, but there was compensation charged, this recreational use immunity statute will not apply to you. So that was the result in that particular case. And I probably understand that that case probably settled given the level of injury. The next case, again, deals with recreational immunity. This case is called Lena versus Crockett and Company. It also deals with Government Code Section 831.4, which provides that a public entity or a grantor of a public easement is not liable for any injury caused by the condition of a trail. It's called the trail immunity. The facts of this particular case is this company had granted an easement to the city of San Francisco along a golf course, allowing people to use that easement as a trail for recreational purposes. Someone was using the trail, they got hit by a golf ball. They argued that there were things that it could have been done to prevent this accident. There could have been a fence built so as to prevent golf balls from hitting people using the recreational trail. The court disagreed. The court said that this recreational immunity, this trail immunity, is very broad, and that to impose any kind of requirements to make a trail safer, to put handrails on a trail, would inhibit people from granting public easements for recreational use. So the court granted summary judgment based on this trail immunity, finding that there's no duty on the behalf of the person who granted the land to the city of San Francisco to do anything to change the contours of the trail. My third case in a row here is, yeah, we're going back to Charlie Redfield.
Yeah, nice try, Kurt. So I as Christine mentioned in her introductory remarks, we primarily do defense work, and I'll be honest, I'm going to have an unapologetic and unabashed leaning towards the defense side, which is going to really come out in the next case that I'm going to be talking about, this Mohammed Hanif versus the Superior Court of Santa Clara County. Quite frankly, this was a very, very bad case for defendants in personal injury litigation, which involved a plaintiff who is so severely injured that that plaintiff would be entitled or be receiving some sort of vocational rehabilitation evaluation. What I just said is pretty much what this case is about. Mr. Hanif had sustained very bad personal injuries. Mr. Hanif was going to probably need to switch careers and was going to be seen by, on his own behalf, a vocational rehabilitation expert. Defendants thought, well, in fairness, we'd like to have our own vocational rehabilitation expert evaluate Mr. Hanif as well. And they ended up, after a meet and confer process, with a letter and then serving a demand, which really wasn't authorized by the Code of Civil Procedure, asking for a vocational rehabilitation evaluation by their own retained consultant. The plaintiff said, no, this is not authorized by the Code. You're not entitled to have your vocational rehabilitation expert evaluate my client, the plaintiff, so forget it. So the defendant made a motion to Judge Folan in Santa Clara Superior Court, who is a person I worked with when I first came out of law school, is a good defense counsel, and I appreciate her ruling in the defense favor and said, yes, the defendant is authorized to have a vocational rehabilitation examination or evaluation, and the plaintiff took a writ of mandate with the appellate court, and the appellate court said no. The defendant, even though the plaintiff would have this unfair advantage, although that wasn't set forth in the opinion, that's my spin on the opinion, would be entitled to get that advantage because the methods of discovery, which were set forth in CCP section 2019.010, while it includes a physical examination as a matter of right and a mental examination upon motion or agreement, does not allow any type of vocational rehabilitation evaluation. So, in a case where there is a traumatic injury to a plaintiff who will be looking to switch careers, the plaintiff has a big advantage. The plaintiff's expert is entitled to have the in-person evaluation, have testing, any of the other things that are done by people who are evaluating future vocations for someone who has a traumatic injury. And as this case stands for the proposition that the defendant has none of that, the defendant's expert or consultant will have to rely upon whatever was done by the plaintiff's expert and either critique it or just bootstrap it, but does not get the right to have their own independent investigation or testing. So it was a very bad case for the defense. The California Appellate Court took a very strict interpretation of the Code of Civil Procedure. Probably it's legally correct, but from a practical point of view, it is not good for the defense. The next case I'm going to talk...
Mine.
Oh.
You don't get the jump.
I do? I thought...
I got the horse riding case.
This one?
You can do it. Go ahead. It's all right. I will tell you one thing about that Hanif case. There was almost a collective gasp. Oh, sorry.
Thanks, Christine.
There was almost a collective gasp by the defense bar. You've seen the emails that I saw from numerous other defense counsel. There was a lot of frustration about that because that really does put the defense in a very difficult position, but we'll figure a way around.
Yeah, perhaps it's good if I'm going to be doing the balloon case, I do the horse case too, because they both deal with the primary assumption of risk. And the Swigart case, we're calling the horse case, is on page 14, and the Grother case is on page 15. Both these cases have similar issues, so I'm going to briefly describe both, and I'll go back and forth. And both have a very good opinion for the defense. So I'm counterbalancing here yin and yang with a bad defense case with good defense cases. First, a quick primer. You're probably already familiar with the doctrine of the primary assumption of risk doctrine. So what this is that if an activity is such that there's an inherent risk involved in the activity, such that by trying to reduce the risk or eliminate the risk, you completely destroy the whole benefit or reason you're doing the activity. The plaintiff cannot sue somebody who injures the plaintiff that happens during the activity, absent some exceptions, which I'll get to now. And the first case to talk about this, where the Supreme Court recognized this concept again, assumption of risk had been around for a long time when, in the old days, when the contributory negligence acted as a full bar to a plaintiff's case rather than apportionment of fault. The Supreme Court, in a touch football game case, allowed the assumption of risk doctrine to bar a plaintiff from suing a co-participant in the touch football game who injured the player. The Swigart case involved an activity that was called a endurance horseback race. And they called it endurance horseback riding event. It seemed like it was some sort of a race, but it was a rough and tumble event according to the facts of the case. Riders would be brushing up against each other, and trails were going pretty fast. The defendant in the case, Carl Bruno, apparently had been riding too close to Ms. Swigert's horse. They apparently had not been playing well, shall we say, during the activity. And at a certain point, Swigert got off of her case, and while she was on the ground, Bruno's horse hit the horse in front of it, causing that horse to kick Bruno's horse. Bruno's horse bolted, throwing Bruno onto Swigert, which caused her injury. And so Swigert sued Bruno for causing her injuries. The defense held that Bruno, given this activity, did not really owe Ms. Swigert a duty of care and could not be sued for negligence because everything that occurred was just part of the activity of horseback riding. Ms. Swigert said, well, this was not really part of the riding and should be treated separately. And the court in the Swigert case decided not to get into the nitty-gritty. There was apparently video of the event, and it showed that these horses were riding close together, that they were going fast, there was contact, and that something like this would be an expected occurrence as part of the activity. And so that in that situation, the assumption of risk bar applied. The other case that dealt with primary assumption of risk is this Grother case, which is on page 15. Erica Grother bought a ticket to participate in a balloon ride, and it was in conjunction with a vineyard. And unfortunately, when the ride was reaching an end, and she was either in a basket or a passenger compartment, I couldn't quite figure out from the case what it was, the descent ended up going faster than anticipated and wasn't straight down, was sort of at an angle, and such that the person who was controlling the balloon essentially lost control during the descent. The balloon struck the ground very forcefully and caused all the people inside the compartment to hit each other and hit the sides of the compartment. Luckily, no one was killed, but apparently Ms. Grother did sustain personal injuries. And so she sued the hot air balloon company for negligence in the way that the ride was handled. The hot air balloon company brought up the primary assumption of risk doctrine, saying that the hot air balloon activity inherently has a risk of a descent which involves it not being completely under control. And the plaintiff countered, well, you could reduce that risk by having some way to guide the balloon and control it more. And the response, which was adopted by the court, was that, well, if you have all of these ways of controlling the balloon, it in fact changes the nature of the activity. It is not a hot air balloon activity. It is more aligned with some sort of an airplane type of a ride, in that as part of the activity there is going to be this buffeting by the wind, and things can happen. So the court found that that activity, you couldn't have these measures that the plaintiff talked about that would somehow make it safer. One of I think the best part for the defense in both let's see if I have any computer skills, both the Swigert and the Grother cases, is that the courts rejected a common method by which plaintiffs try to avoid the primary assumption of risk doctrine by saying that the defendants were guilty of gross negligence. And that is an exception. If the facts are such that a jury could find that the defendant is liable for being grossly negligent, then the primary assumption of the risk doctrine will not apply. Just so you know, that the legal standard for gross negligence is want of even scant care or an extreme departure from the ordinary standard of conduct, a very vague standard. And we found that frequently courts will find triable issues of fact when we file motions for summary judgment, not only under these primary assumption of risk doctrines, but also on those cases involving the hold harmless agreements as well, saying, well, there's a triable issue of fact because you put these facts, it shows that the jury could find that the person was acting grossly negligent. And both the plaintiffs in the Grother and Swigert cases maintained that both the jury should be allowed to determine whether the defendants were grossly negligent. And in both courts found that the facts presented to them showed there was no factual inferences that could be made that the defendants were grossly negligent. So that is terrific, because at least now we have some cases that when we are making similar motions for summary judgment on behalf of defendants, there are some standards here. We can compare the actions and activities done by the defendants to the defendants here to show that there was no gross negligence as a matter of law. One other aspect of the Grother case I'd just like to touch on really quickly is one of the other claims that was made by the plaintiff in that case was that the motion for summary judgment should be denied because the defendants failed to take reasonable steps to minimize the inherent risks of the activity by providing some instructions in case something happens. And in this case, the Grother claimed, well, there were no instructions given to us when the balloon took off what should happen if there was going to be any problems with landing, for example, bracing yourself or some other way to protect yourself. And the court rejected that on a causation ground. The court found that that instructions, given the facts they were presented in this case, instructions on what to happen in a situation that occurred here wouldn't have made any difference, that the force of the collision of the basket hitting the ground and tossing people around, it didn't matter if you'd been bracing yourself or whatever instructions the plaintiff proposed should have been given, it wouldn't have made any difference, and the court rejected that as a reason to deny the motion for summary judgment.
So I have a question here on that case.
Oh, I'm sorry, go ahead.
I just wanted to know if y'all have handled any cases regarding the riding bulls. Those are very popular. A lot of my clients are in other states, Nevada particularly, they're very popular. But I do notice that they also have them available for festivals and carnivals where people are getting on these electrical bulls. So is there any case precedent set at all for that? Because assumption risk is really huge with regards to those. Or have y'all handled any like that? Or
I haven't.
Well, I haven't, but usually I do know, this is an ongoing thing where people undertake very dangerous things. What's the one where you hang and you slide along the trees? We've had a couple of cases like that. Usually the ziplining, I've done it actually, very dangerous. Usually what you sign up, when you sign up, you're signing a express contractual assumption of the risk. Usually the courts will enforce those, and that's if they're doing it in the bull riding thing and usually on the back of the ticket it says, we're not liable for all your craziness of falling off.
Or they have those signs.
They do have, and they have the signs, but once again they're going, was there something in that particular person's ride where their risk was increased? The pads on the side were pulled away. Potentially the person was so intoxicated and shouldn't have been on the bull in the first place, but you're kind of putting the onus on an 18-year-old kid who's giving the tickets. So potentially there is ways away, but usually the primary assumption of the risk and the express contractual assumption of the risk should take care of them, but it's factually dependent, if something outside the ordinary happens. And they'll obviously come up with an allegation about that, but it's certainly summary judgmentable. Yep, I'm up. And this is more, this case is really something that I've actually run into in the last 2 years twice. Where because of trees blocking views or trees coming into a person's uninsured's yard, they've cut the trees and somehow damaged them and caused, a lawsuit. My particular war story about this is when I was a young lawyer.
You still are.
Yeah, that's true. My next door neighbor, who I just moved in, she goes, I'm really having trouble with the neighbors on the other side. They have these trees that are falling into, the stuff's falling into my yard all the time. I want to sue them. They won't let me cut the trees. And I take it to the senior partner. I go, hey, I got my first client here. They were ready to go. He goes, no way. Never, ever handle a tree case unless you're on the defense, because they go on forever. And that one did go on, that case. They did get a lawyer. They entered into litigation. It lasted 3 years. I can't imagine how much they spent. It was just insane. And this particular case, which I think is Full versus Kanakami, kind of opens your eyes to the potential liability here. In this particular case, neighbors. One neighbor is very frustrated by the trees in the other person's yard, blocking his view. I guess they had a long period of discussion and grumbling about this. When the plaintiff wasn't home, the defendant sent gardeners in there to cut down the trees. And, you know, obviously when you're young, you know, might think, hey, you know, what's the damage? You cut down a few trees. Well, California statutes actually provide for doubling and trebling of the penalty of the damages. California Code of Civil Procedure, Section 733 provides for trebling. Civil Code Section 3346 provides for a doubling penalty. And usually penalties are only for economic damages. And the economic damages in this particular case were significant. You know, the cost of putting in new trees, the stabilization of the hill because of the cutting down of trees. But these statutes were deemed to go even further, because the jury did award, this went to a jury trial, did award damages for annoyance, aesthetic loss to the property, you know, general frustration for this happening. The court, under these statutes, trebled everything. And, you know, we all work in the insurance business, and we know that trebling isn't covered by insurance. So to the extent this person had insurance coverage in this particular case, the trebling would have been on them. This could have been a very expensive little neighbor fight, costing them several $100,000. So the warning, don't cut down your neighbor's trees. I think the next case is, oh, it's a difficult case. Charlie, that's yours. You do all the difficult ones.
Actually, Kurt's giving me all the good defense cases. This case had a couple issues, but for us defense counsel, thank you, this case was terrific for us for our ability to now, under certain circumstances, be able to provide additional evidence in a reply brief in opposition to a motion for summary judgment. My experience is that most motions for summary judgment are filed by defendants. And the general rule is that the defendant, in filing the motion for summary judgment and setting forth the facts supporting the motion, really only gets one crack at it, right in the beginning when the defendant files the motion. And essentially the defendant really has to be able to anticipate all the arguments that a plaintiff is going to make, because it's very difficult, if not impossible most times, until this case at least, to have the court recognize and willing to consider facts set forth, new facts set forth in a reply brief under most circumstances. So this Jacobs case, let me start off describing it, and this is at page 18. It's Jacobs versus Caldwell Banker. Caldwell Banker was selling a foreclosed home, vacant. Jacobs was one of two people who was looking at the home at the time. The backyard of the home had a drained or empty swimming pool with a diving board, and I think adjacent or behind the diving board was a fence. And Mr. Jacobs wanted to see what was on the other side of the fence, so he decided to climb onto the diving board to take a look at what was over on the other side of the fence. Unfortunately, the diving board ended up having a rotted base, and so he fell straight into the empty pool and sustained personal injuries. Caldwell Banker moved for summary judgment on a variety of different grounds. There was no evidence that it breached a duty of care. There was no evidence that Caldwell had actual or constructive notice of dangerous condition of the diving board, et cetera, et cetera. Related to that. And it's important, I kind of skipped over when I got into the motion for summary judgment, that when the plaintiff filed his complaint, the complaint only specified that the diving board was a dangerous condition, didn't mention the pool. Well, in the opposition to the motion for summary judgment, for the first time out of the blue, the plaintiff says, well, the defendant's taken too narrow a view of this case. It's not only that the diving board was a dangerous condition, but so was the empty pool. The empty pool also posed a dangerous condition in conjunction with the diving board. In response to that, the defendant supplied a lot of new evidence that had not been set forth in the original motion to counter this new argument that the empty pool constituted a dangerous condition. And part of the reason that the court considered this new evidence is because the plaintiffs didn't even object to it. But the court, citing the law which says, generally speaking, no new evidence should be submitted in a reply, allowed the evidence under these circumstances to come in, and found that even if you were to consider this empty pool, which had not been pled, and the court mentioned that, this was an open and obvious condition to the plaintiff when he was there. And the court also found that there was no evidence of actual or constructive notice that this diving board could pose a dangerous condition. And after this case was decided, it was originally an unpublished opinion, and an unpublished opinion has no precedential effect in California. And the Association of Defense Counsel actually petitioned the court to publish the decision because of this great new law as far as considering new evidence in reply. And fortunately for the defendants, the California Appellate Court agreed to publish this case. So now we do have some precedents that defendants can have new evidence submitted in a reply brief under certain circumstances. So that's very helpful for us. Thank you. The next case I'd like to discuss is at page 20 of your materials. It's the Petipus versus Ford Motor Company case. And this is an asbestos case. And I got to tell you, I'm already a little intimidated to be talking about this case because in the back is my partner, Guy Steelson, who does these cases quite a bit. And I'm fairly certain that I am not going to get this case exactly right. And I do request that, Guy, you refrain from saying you're wrong until after I finish. I would appreciate it. One thing we haven't mentioned when we were introducing ourselves, and unfortunately we don't have any people from that team presenting today, is we do have a very good and successful environmental team who do asbestos cases, toxic cases, silica cases, et cetera. So if any of you have those types of cases, we do those quite a bit. And I don't do a lot of them, so bear with me if I don't get this exactly right. But I think I have a pretty good idea of this case. This case has a bunch of different issues on it, although the facts are really fairly simple. It involves two plaintiffs who are husband and wife. The husband had worked for a long time at an ENCO, which became Exxon later, gas station. The allegation is that while he was working there, he became exposed to asbestos fibers floating in the air that came from brakes. And his wife eventually contracted an unfortunate cancer called mesothelioma, which is linked to asbestos exposure. And so the allegation is that she what's called secondary exposure to asbestos. So he's nodding his head, I'm right so far, and thus could make a claim. So the plaintiffs sued a bunch of defendants, as Guy will tell you in detail. They sue anybody and everybody who could potentially be responsible for supplying asbestos to the place where the person contracted or could be exposed to asbestos. So they sued Exxon. I'll talk about the Exxon case first. In that case, Exxon, I believe, made a motion. No, it was a defense verdict, so it went to trial. Exxon claimed that the wife couldn't make a claim for secondary exposure to asbestos as a result of the husband being at the gas station because she wasn't married to him when he was working there. Not a very difficult legal proposition to understand, but they felt that no, you may have gotten it someplace else, but you didn't get it there. And what was also interesting in this case there was a strict liability claim that was being made against both Exxon and Ford Motor Company. The allegation being that the brakes in Ford vehicles were responsible for having this asbestos in the workplace. And the plaintiff made what's called a strict liability claim, which you're probably familiar with, whereas, again, this is not the negligence standard. It has to do with whether there's a defective product, and defective product causes injury. It's a much simpler way for a plaintiff to establish liability, especially in a case like this where, quite frankly, the activities had happened decades before the trial, so the evidence of this is pretty scant. And the court upheld defense verdicts on this case on the strict liability claims against both Exxon and Ford. For Exxon, because Exxon or Enco at that time was not the supplier of the defective product. They weren't supplying the defective brakes. They just had them in their gas station. They could not be considered someone as a manufacturer or in the stream of commerce who could be liable for strict liability under those circumstances. Now for Ford, it was an interesting decision in that one because they were being sued for, there are different prongs of strict liability for products liability. There's design defect, manufacturing defect, and failure to warn. And the two ways that the plaintiff was suing Ford was for design defect and failure to warn. And in this case, they found that the brake assemblies that were part of the Ford material were not manufactured by Ford. And so they couldn't be held liable for any design of these brakes which had asbestos because they weren't responsible for that. And there couldn't be any failure to warn because the whole purpose of a Ford automobile's brakes is for braking. And it was undisputed that there was no asbestos exposure from just the normal use of brakes. What would happen would be is when the brakes were being fixed or replaced, it could be opened up and the asbestos fibers inside the brakes could be exposed to the air, and that's how someone could get exposed to asbestos. But there was no way Ford could anticipate that would be what would occur, especially because their evidence Ford presented that there were other ways that someone owning a service station could change or fix brakes which would not involve the release of the asbestos fibers. So the court found that Ford could not be liable for failure to warn as well. So I got two good defense cases back to back. Thank you, Kurt.
You're welcome, Charlie. As many of you know, attorney's fees provisions in contracts can be a driver of litigation. This case discusses those particular aspects of attorney's fees. In this particular case, the facts were someone bought a dental practice, contractual relationship. The contract had a broad attorney's fees contract provision in it. Lawsuits ensued. The person who bought the dental practice sued both for breach of contract, they didn't get what they thought they were going to get, for fraud, various tort claims. Under California Civil Code 1717, if you have an attorney's fees contract, a provision in a contract, it's reciprocal. It goes both ways. So even if it's one-sided, the court interprets it to work both ways. But there is an exception in Civil Code Section 1717, I think it's 1717B2, which says, hey, right before trial, if you dismiss your claim, there's no right to attorney's fees based on the contract. So the person who bought the dental office dismissed their case right before trial. The defendant went to trial on his cross claims and lost them all. Nevertheless, the defendant moved for attorney's fees based on the contract. And the first thing the plaintiff said, well, hey, I followed that exception. I dismissed my case before trial. And the court said, that's right, you dismissed your contract actions. The question is whether your contract is broad enough to encompass tort claims. The court reviewed the contract, found it was one of those far-reaching attorney's fees contracts that provides for any action brought based on this contract or anything arising out of the other side's entitled to, the prevailing party's entitled to attorney's fees. The court granted attorney's fees to the defendant who lost their cross-claim and didn't really actually have to defend these cases at trial, and they granted significant attorney's fees. So it's really important, and I know you guys deal with this all the time. It drives litigation. The attorney's fees issue is always dangerous when it's in a contract or provided by statute. I believe, unfortunately, we are now going to move to an area of law that I don't practice directly but deal with all the time, and that is coverage. The first case I want to talk about, and I'm going to kind of deal with these in a summary fashion, and this relates to the exclusion in auto policies for normal use. The facts of this case are an employee had a car, I think it was PG&E again, and they could use that car, and PG&E agreed, they could use that car for both business purposes and for personal purposes. An accident occurred. The PG&E was found they're not liable because the person was actually doing a personal errand, so outside the course and scope. The person turned to their own insurance policy and said, well, you know, I have an insurance policy for my car, you should cover me. There's something called the normal use exclusion, and it provides that you can borrow your brother's car and you're covered by your own insurance policy. But if you use a car normally and regularly, that is excluded from coverage. And the court, it made a lot of economic sense because, you know, people would attempt to insure several different vehicles under one policy. The court said, no, you're not covered. For people who have company cars, this should be a concern, just to keep your eye on what your policy covers, and you can change these normal use exclusions. You could certainly request that your employer change their insurance policy, but it's something to keep your eye on because the employee was left with a personal injury action and no insurance coverage. The next case I'd like to talk about is Energy Insurance Mutual versus Ace American Insurance Company. This is the professional liability exclusion which was at issue. As you know, many policies don't insure for performance of professional duties. That's a separate type of policy. In this particular case, the facts were a subcontractor was retained to mark out where pipelines were underneath the ground because they were doing drilling and excavating. They didn't do it well. The excavator hit a line, huge explosion, a lot of personal injury. The people who marked out the lines were sued for indemnity by the excavator, and their insurance company took the position that the professional liability exclusion in their insurance policy covered the actions of the people who were marking out where the pipelines were. I actually want to read a little. The court commented, even though it was a personal injury action saying there was negligence, if the failure to provide professional services are inseparably intertwined with the non-covered conduct, there is no coverage even where the particular claim appears to be covered. This was certainly for the insurance company a large win because of the amount of the indemnity. But it was kind of a surprising result for me that it would seem that they negligently failed to mark out the pipelines. But the court said, no, those are professional services and fall under the professional exclusion. I'd like to move on to the next case, which Montrose Chemical versus Superior Court. This is a case that relates to many other cases that have worked their way through the courts over the last 20 years. They relate to toxic sites and whether insurance companies owe indemnity for the cleanup of those sites. At this particular site, over the environmental damage to this site had occurred over 40 years. So there were minimally 40 different primary policies at issue. Because this site was, I believe, it was chemical corporation, they had large excess policies. Well, obviously, there is a huge fight about exhaustion. The excess insurers want complete horizontal exhaustion from every policy before they start kicking in money, while the insured many times wants just vertical exhaustion before all the excess policies are in play. More money to play with. They only have to deal with one deductible. Deductible's extremely large in these type of policies. The case goes to the Court of Appeal. The battle is what constitutes exhaustion under the policies. If you have a 40 years worth of policies, you have to, do all primary policies have to be exhausted, or can just one be before the excess is in play? What I really believe happened here was the trial court had 400 lawyers in the room with different arguments, and said, I think I'm just going to make a bright line rule. The bright line rule is you need to only exhaust one policy and you have all the vertical policies, and then you got all access to all the excess policies. The Court of Appeal said, no way. You're not putting this all on us. We're sending it right back to you because all of these policies have different languages. They were issued by different companies, and the exhaustion requirements are different. There was 140 excess policies. My personal feeling is the Court of Appeals said, no way. You're the trial court. You figure out policy by policy what's exhausted and what's not exhausted. You're not going to get away with a bright line rule. So the crux of the case is the exhaustion is on a case-by-case basis. It's dependent on the language of the policy. So that's that one, and I gave myself 4 coverage ones. This one I kind of liked. I've been in this situation. As I said, I do a lot of housing cases. There was a case where the insurance company, we were in mediation, and it's kind of a 3-way mediation. The client has their own personal counsel. I'm representing them on the defense side against the plaintiffs. And the company and company's coverage counsel and the personal counsel are fighting whether or not there's coverage. And what came up was they said, are going to rescind this policy. We did not insure you to be a landlord. You were a commercial property doing non-landlord type things, and we are going to rescind it. And it was the first time I heard that in a mediation. I mean, the case eventually resolved. In this particular case, the same situation kind of occurred. The insured fills out an application. 6 months afterwards, they're sued by a bunch of tenants for habitability, numerous things related to those habitability type torts. The insurance company, it's tendered to the insurance company. The insurance company rescinds. They go, hey, we asked you in the application to tell us you'd fixed everything and that there was no there was no commercial businesses going on there. You materially misrepresented in your application, and based thereon, we're going to rescind. The California Insurance Code allows insurance companies to rescind for material misrepresentations. So far, so good. But it went to the Court of Appeal. The trial court granted summary judgment on the bad faith lawsuit, saying you can rescind. There was a material misrepresentation. Court of Appeal took a different view. They looked at the claimed misrepresentations, and they said, no, your questions were ambiguous. The landlord said that when you asked me whether everything had been fixed, I said everything had been fixed, and that was more or less correct. There were certain things I didn't know about, but that wasn't a material concealment or misrepresentation on my behalf. The Court of Appeal agreed. The question was worded in an ambiguous fashion. The second question was, you don't allow your residential property to be used for commercial purposes. And the question was a little more ambiguous than that, but that was the kind of the thrust of it. And he said no. The court said, the insurer said no, but certain people do run businesses out of their apartments. The Court of Appeal said, but they don't do it regularly. They're not like open from 8 to 5 selling liquor. They're just, people have some home businesses there. So it was ambiguous. Court found neither one was material. Court didn't allow the rescission and allowed the bad faith action to go ahead. Obviously, when you make that call to rescind a policy, it's a big call, and it really needs to be done very carefully, especially if it's based on the application. Take a close look whether any of the questions that you're claiming are material could be seen as ambiguous. I think, no, I've got another one. This one, actually is a pretty straightforward coverage case. Tested in Field and Gas and Food versus Mid-Century Insurance. And the issue here is what constitutes a collapse under the policy. In this particular case, there were underground tanks. The underground tanks were inspected as they have to be. The owner was informed that though collapse wasn't imminent, they were slowly degrading and would fail over time. The property owner turned it over to his insurance company. The insurance company, citing the collapse provision in their policy, refused coverage. Lawsuit ensued. There was specific language. We do not consider a collapse. Let me just get the language. I want to be as clear as possible. Under California law, when the term collapse is undefined in an insurance contract, a substantial impairment of structural integrity will not constitute a collapse unless the policy language specifically supports a broader interpretation. What we had in this particular case was just general collapse language and not anything about future infringement leading to a collapse. The insurance company refused coverage, and it stood on appeal. Obviously, when the issue of a future collapse is tendered, the policy has to be closely looked at to see whether it is the generalized version that was addressed in the court here or something more specific in the particular policy at issue. And this one's actually kind of easy, except for the name, Zabilaga versus Allstate. Uninsured motorist case. Allstate gets hit for, they tender their $15,000. Case goes to mediation. The award is $35,000. Allstate, the insured or bad faith suit ensues. Allstate takes the position, hey, we had a doctor who said this person wasn't that injured. We had a good faith basis for, not paying over the policy limits here, or not paying the full policy here. The court said, yeah, most of the time that's correct. But here, after the IME, the person sought further treatment and got new x-rays and got a new opinion from another doctor, which the IME doctor for Allstate did not review and did not opine on. Hence, there wasn't really, in the court's view, a genuine dispute because Allstate hadn't evaluated this further information. And therefore, the general dispute doctrine and out for insurance companies would not apply. This case is, we're going to skip that case. If anybody has questions about it, it's extremely complex. And Charlie Redfield has a funny joke to tell you in addition to some construction cases. No pressure.
Unfortunately, I don't, but I know we are running out of time, so I'm going to cover this pretty quickly. I'm going to cover 3 construction defect cases, which all deal with the Right to Repair Act. The first case is the Aqua Vista case, which is on page 34. Those of you who do construction defects cases are probably familiar with the Right to Repair Act. This is codified in Civil Code sections 895 and et sec. I love saying et sec, makes me sound smart. In those sections require that before litigation can be started, the persons claiming defects in residential construction must give the builder notice of the alleged defects and an opportunity to inspect and repair. The first two cases, the first one being Aqua Vista, and the next case I'm going to go over, the Gelati case, both deal with interpretations of statutes. In the Aqua Vista case, the Homeowners Association sued a supplier of pipe used in the construction of condominiums, claiming that the pipe was defective. And each side tried to either use or defend themselves against the Right to Repair Act. The plaintiff, the Homeowners Association, only sued for grounds on Right to Repair Act on the grounds the supplier's negligence had caused a violation of the act. The Homeowners Association conceded they were not making a strict liability claim. In an interpretation of Civil Code Section 936, which generally states that the negligence standard does not apply to material suppliers like the defendant in this case, who is just a supplier of product, then that there can't be a negligence standard with respect to claims which strict liability applies, which was in this case. And the manufacturer claimed that Civil Code Section 936 still required the plaintiff to prove that the manufacturer was negligent or had breached a contract if strict liability was not alleged. The trial court had disagreed with this interpretation. The appellate court reversed a verdict in favor of the Homeowners Association, finding that there had to have been some finding that the part manufacturer was negligent or had breached a contract to be liable under this section. And sort of the next case, Gelati, at page 36, it seems inconsistent when I describe it to the prior case, but again, it deals with interpreting the statute. In the Gelati case, a homeowner claimed that a contractor had caused 2 trees in the homeowner's front yard to die as a result of the contractor's negligence. The court held that the plaintiff could not make a common law negligence claim because that claim was barred by the Right to Repair Act. And also, a case went to trial, and the jury found that the contractor was not negligent. In that case, there was support for the claim that the plaintiff could not make this common law negligence claim. It had to relate to the Right to Repair Act, which had not been done. The last Right to Repair Act case I'm going to go over is the Blanchett case, which is at page 37. And this case involved the various deadlines, 2 in particular, which are involved in this act. So the homeowner had provided a detailed claim, unfortunately not detailed enough, about what the builder had done wrong, and the builder had not responded in sufficient time. The builder claimed that because the claim submitted by the homeowner was not sufficiently detailed, that the homeowner had not complied with the requirements of the Right to Repair Act and thus could not proceed with a civil litigation, civil lawsuit, which did not involve the Right to Repair Act. And the court said the builder was correct, but unfortunately, the builder had taken 21 days to respond to the claim instead of the statutorily required 14 days to respond. And because the builder was late in responding, the court said, too bad, builder, you've essentially waived whatever disagreement you have with the claim submitted by the homeowner, and thus the homeowner could proceed with the civil action. So with that, I think we have one more case that Kurt's handling.
And this is just, this particular case and deals with an indemnity on a construction site. The importance of this case is that it makes what subcontractors hoped was a bright line rule that said if the general is guilty of willful misconduct or active negligence, the sub's rights to indemnify the general contractor will not come into play. In this case, strange set of facts, the subcontractor of a subcontractor of the general contractor, an employee of that bottom subcontractor, falls through the roof. The general contractor's employee had cut a hole in the roof and not put appropriate warnings and safeguards around it. The injury occurred. The court ruled in this particular case that it's, even under those extreme circumstances, it's still a question of fact as to whether indemnity is owed by the subcontractor to the general contractor. It was a boon for general contractors, this particular holding, and certainly put the indemnity provisions of subcontractors at risk, even in extreme situations. The court said, this is a question for the jury. It's a question of fact that can't be answered on summary judgment, even under these extreme facts. That is all for the California update. Please join us for a little libation, a quick break, and then we'll have the marijuana seminar, which I'm really looking forward to, coming up.
Thanks to Kurt and Charlie. It was a great presentation. And we do have some cookies right over there, coffee and snacks, and we will be starting again in 10 minutes. 2 presentations left to go. Thank you so much. And for those of you on the webinar, we will be back, and I should have said that there are links to all the materials that were provided to you when you registered. So hopefully that you'll be able to follow along and download any of those documents. Those documents will also be available on our website. Thank you very much.